Six guy, he a visionary.
Seti Nash, the hood lawyer. I think somebody didn't mean to make the call, but like you better call Saul, I got a solution for HoneyKomb Brazy, y'all.
The affidavit, deputies found a Gerson 9mm pistol near where Fuller was sitting and a Smith & Wesson AR pistol under the third row seat near where Jones and Hall were sitting. All three were prohibited by law from having guns. Fuller, because of a protection from abuse order signed by.
Due to aforementioned violations, a traffic stop was performed on the vehicle at exit 22 in Criollo on the off-ramp at I-65 southbound. Due to the intent of the vehicle, the driver was asked to exit the vehicle and come back to the deputies. When the driver was later identified by his Georgia driver's license as Mason Fuller exited the vehicle, he was wearing an outer carrier equipped with a soft armor that was labeled with enforcement. Fuller was asked about the other occupants in the vehicle, and he advised that there were two other individuals in the vehicle besides himself. Due to the body armor, he was asked about the presence of firearms, and Fuller stated there was a firearm under the driver's seat and said there was at least one firearm in the back seat. Due to the presence of multiple firearms in the vehicle, the other occupants were requested to exit the vehicle and come back to deputies. The first person to exit the vehicle from the back passenger side door was Nashawn Jones. The next person to exit the vehicle was Miguel Hall. The vehicle was cleared for officer safety reasons. Deputies quickly noticed a strong odor of marijuana emitting from the vehicle. An NCIC criminal history check was run on Fuller, Jones, and Hall. Based on the checks, it was determined that all occupants of the vehicle were prohibited persons forbidden to possess firearms and or ammunition. Fuller was prohibited based on an active protective from abuse order issued in DeKalb County, Georgia on September 28, 2023 and expired on September 27, 2024. Although you are generally prohibited from suing your employer or a coworker for an on-the-job injury, Alabama law allows you to bring an action against a coworker when the coworker's willful conduct caused the injury. Now, I'm going to show y'all exactly what injury was caused. Breach of contract that they did is going to be an injury amongst severe emotional distress. Take a look real quick. I'm going to knock this out for y'all. It's negligence. Negligence is the most common of tort cases. At its core, negligence occurs when the tortfeasor, the person responsible for committing a wrong, is careless and therefore responsible for the harm this carelessness caused to another. There are 4 elements of negligence case that must be proven for a lawsuit to be successful. All 4 elements must exist and be proven by a plaintiff. The failure to prove any one of these 4 elements makes a lawsuit of negligence deficient. The 4 elements are duty, breach, constatation, harm. A baseless negligence lawsuit will require a person owning a duty to another person, then breaching that duty, with that breach being the case of the harm to another person. Duty. The first element of negligence is duty, also referred to as duty of care. What is a duty? In its most, simplistic terms, it is an obligation to either do or not do something that will harm someone else. Think of duty as an obligation. We all had a duty or an obligation to act reasonably or reasonably refrain from certain actions in such a way as to not cause injury or harm to another person. For example, as drivers of automobiles on public roads, we all have a duty to follow the rules of the road. It's our obligation as licensed drivers to do so. We understand that rules like speed limits are imposed to protect others. A reasonable person understands that failure to follow these rules of the road may result in harm to another person. Scope of one's duty. We ain't finna do all that. Breach. Once a plaintiff has established and proven that a defendant owned a duty of care to the plaintiff, the second element of negligence a plaintiff must prove is a breach of duty of care. This is when a person or company has a duty of care to another and fails to live up to that standard of care. A plaintiff must prove that the defendant's act or omission caused the plaintiff to be exposed to unreasonable risks or of injury and or harm. In other words, the defendant failed to meet their obligation to the plaintiff and therefore put the plaintiff in harm's way. We're not going to go through all of that stuff. Consultation. The third element of negligence is consultation. There are 2 types of negligent consultation: actual cause and proximate cause. Actual cause is sometimes referred to as the cause. In fact, that means that but for the negligent act or omission of the defendant, the plaintiff would not have been harmed. This is known as the but for test. For example, a driver's passing through an intersection with a green light. Driver B runs the red light and strikes driver A's vehicle and injures driver A. Clearly, but for running of the red light by the driver B, driver A's vehicle would not have been struck by driver B, and driver A would not have been harmed. So All of this stuff absolutely comes through. Harm can come in many forms. This is the fourth element. It can be economic, like medical costs and lost wages. It can be non-economic, like pain and suffering or extreme emotional distress. It can be harm to a person's body, to a family member, or to a property. However, if one is not harmed in some way, the fourth element of negligence is not met, and the lawsuit of negligence will not prevail. And he 100% had loss of wages because when HoneyKomb Brazy was out, it was charging for interviews, and on top of that, was making music. Back to it. This is going to further prove what I was talking about. Look at Jay Prince Jr. Jr. gave me access to his page so that I could keep y'all up to date and give you his info. If you want to write him or send something, if you have any other inquiries, you can DM his page or DM me at I Hustle No Luck. Free Junior, MobTies for life. And here you go. He's putting out all his info when he was in Beaumont, Texas. And yeah, so that absolutely is given the power of attorney, aka the power of estate, which means that this man is gainfully employed by MobTies. And let's go ahead and see exactly what he said about the situation with HoneyKomb Brazy. I usually don't do the internet shit, but I'm going to address this one time. I took all proper precaution when hiring a security guard. I did a proper background check. He had no background and had all the proper credentials. During his time working, he got a restraining order put on him in his personal life and didn't disclose this to anyone. What he did in his personal life, it was kept confidential, and me or any of the team was informed he was prohibited. Yeah, but ignorance of the law is no excuse. That's like you hiring somebody to be a driver of your vehicle and stuff like that. That does not mean that your ass, if this person gets into an accident, can just walk away scot-free. So, let me further my point real quick. Catch y'all up.
Now, is it a bit of a stretch? A little bit. But I think once they admitted, HoneyKomb Brazy's brother admitted that they weren't responsible for the security, and essentially the security was provided by MobTies, which means that is your employer, because when HoneyKomb Brazy said, I am not making any money, it's going all to my label, your label owes a duty to you to keep you quote unquote safe if they're paying for your safety. And one thing that has been shown that I have proven is that that guy in particular has been in direct contact with financial benefits from MobTies, which to me, I leave it to y'all the jury. The visionaries are not the juries. The jurors right now. I leave it to y'all to absolutely point out the truth, or realize it, should I say. The truth of the matter is that they may not have intentionally set him up. I can walk that back and go, I don't think they set him up, but I do believe they were negligent in their duties. And since they were negligent in their duties, it does not matter, because ignorance of the law is no excuse for breaking it. One thing that I was able to show is they 100% violated a labor law. You can break that contract now. Now, if they want to recoup the money that they're owed and stuff like that, they can try to get it in litigation. But one thing that they can absolutely sue for is the ability to know that HoneyKomb Brazy is going through mental anguish and the ability to earn money for himself because he is now locked up. And if that's the case, then there is a countersuit that will happen. I think it's just best that MobTies just go ahead and break that contract, leave HoneyKomb Brazy full scale alone, push on with finesse 2 times, and save yourselves. This would do great for publicity and say, you know what, man, we messed up and stuff like that. So in our admission of guilt, we're going to release this man from his contract. He no longer has future obligations to us. And then you can talk to Birdman and then rock with Birdman if that's what you choose to do. But as far as what they did, they cannot deny what I've proven. And what I have 100% proven is that HoneyKomb Brazy should be able to get up out that contract, because there is emphatical proof that, bruh, not only did they mess him up, they messed up big time. And since they messed up big time, bruh, time to smack that contract, bruh. I don't want to say what I really want to say because I'm trying not to cuss, bro. But other than that, man, what do y'all think? Do y'all think that I proved the case that he's able to break the contract? Because there is an admission, bare minimum, that that guy works for them and that they source their security through them. Or should HoneyKomb Brazy just sue the security team and trust MobTies? Because there's a part of that where they can say, well, you know what? We hired him to do a job and they didn't do their job. Because one thing's for certain, two things for sure. When it comes down to it security-wise, when niggas used to check in, it used to be Jay Prince and MobTies were good. But now with a nigga getting picked up from the feds and another nigga a year ago dead, it seems y'all credibility has went down. Y'all stock prices are constantly crumbling. So the bare minimum you could try to do is save face. But maybe I'm wrong. Maybe I'm all the way wrong. Maybe my application of the law is wrong. And maybe I'm just misconstruing things and stuff like that. But I'll tell you what, isn't it worth a shot? Happy New Year's, y'all, man. Subscribe, turn on that bell, stay notified, and share to keep your people aware. I'll catch you on the next one.
What's really hood when I'm through the hood? Nothing be said, we got it overstood. The team fed, yeah, it's really good. Put that on everything, bro, you're never good. What's really hood when I'm through the hood? Nothing be said, we got it overstood.